That's all right. Now tell me.
Paper
this
publication
court is not
doc.
unfair.
Now tell me.
It's my
RBI, that's all right. RBI guidelines ಪ್ರಕಾರ ನೀವು ಮಾಡಿದ್ದೀರಾ. ಅದನ್ನ ರಿಪ್ಲೈ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ. RBI guidelines ಪ್ರಕಾರ ಒಂದು NP ಆದ್ರೆ ಎಲ್ಲ NP ಆಗುತ್ತೆ ಅಂತ. You want to tell that? Leave it.
Yes, my lords.
I have heard Vignesh Shetty enough and more. I am just giving you audience. That's all.
Please,
Only to
my lords, I
impose
got
costs.
to the paper. No, my lords, please
I
don't
did not
repeat the
ask
word that I have
anything.
already been heard Vignesh Shetty.
Definitely, orders I have recorded.
Orders.
I have recorded every order. In every order, what Vignesh Shetty has said. This is highly, I'm not on you, madam. Highly unfair practice on the part of the bank. So banks will be saddled with costs.
In the memo, the first page.
ಎಲ್ಲ ಆಗಿ dictating orders ಅಲ್ಲಿ dictating ಮಾಡಬೇಕಾದ್ರೆ you change the counsel and try to say something else.
Because
No, I'll give a justification for that.
No, I will not accept. I will not accept every justification of the bank.
Notice.
Yes.
My
Registered
lords, if
post.
anything asked
First
from me, then
page.
it is my duty that I
Memo
will
is the first page.
The bank is
Immediately
the
Memo
bank
is
is
written
here.
on I'm not the one who was there earlier.
I'm representing the bank.
No, no, you are not the one. You are not the one who was earlier here. Get Vignesh Shetty, I will hear everything.
And the first one is
My lords, when the invoice is given, then how
No, no, I'm not.
Vignesh
This,
Shetty
that is
can-
what will be
registered
for
post letter to the
imposition of
defaulting
costs.
borrower, irregularity
My
in
lords, if
payment
wrong
and the
submission made
the
before
claim
the
is the
Honorable
same
Obviously,
notice.
that order based on
To
that
me.
submission only court has passed that itself.
So you are telling Vignesh Shetty has made wrong submissions.
That is why.
All right.
That is why, my lords, I am.
Record that also. You are telling
First
Vignesh Shetty has made
notice.
wrong.
First notice
My
ಅಂತ ಇದೆ,
lords,
ಮೇಲ್ಗಡೆ
see, based
1611 ಅಂತ ಇದೆ.
on
That is the
live
one they
streaming,
claim
it
is
is
the notice
My
given to me.
lords, please.
Now,
See,
on
for
the
that
next
only
page,
I am
my
here.
lord.
Because for that only, see, I was not knowing all this thing
There
which
is a
has happened
postal receipt
earlier.
which they have
When the
produced
bank
a
has
copy
come
of
to me
that.
by along with the invoice.
Your officer
ಅದು ಡೇಟ್
My lords,
2011-2023.
he was here.
ಆ ಪೋಸ್ಟಲ್ ರಿಸೀಟ್ ಕಳಿಸಿದ್ರೆ 14/11
Let him
ಪೋಸ್ಟ್
become
ಮಾಡಿರೋದು
aware.
20/11
Yes.
and they have themselves produced the covers and return covers. ಅದರಲ್ಲಿ the third and fourth page 2311 it is attempted, 2411, 2511, 26
Third and fourth page ಯಾವುದು?
they have produced the copy of the return notice. ಆ ಪೋಸ್ಟಲ್ ರಿಸೀಟ್ ಆದ್ಮೇಲೆ
ನೋಟಿಸ್ ವಾಪಸ್ ಬಂದಿದೆ.
ವಾಪಸ್ ಬಂದಿದೆ ಅಂತ they have produced saying unclaimed ಅಂತ ಹೇಳಿ.
Unclaimed date ಏನದು?
ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ರಿಟರ್ನ್ ಟು ಸೆಂಡರ್ is 3011. ಮಧ್ಯದಲ್ಲಿ 23, 24, 25, 28 is there.
All right.
Now my lord, the last page is the sale notice that they have produced, paper will publish ಮಾಡಿರೋದು. That if my lord sees, it's at the bottom of the page. ಮಧ್ಯದಲ್ಲಿ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಅಂತ ಒಂದು ಪಬ್ಲಿಕೇಶನ್ ಇದೆ. That is dated 1811. That auction
One minute. Where do you get it?
here my lord, at the bottom of the page, square ಆಗಿ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಅಂತ ಪಬ್ಲಿಕೇಶನ್ ಇದೆ. ಪೇಪರ್ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ.
Yes, yes.
ಅಲ್ಲಿ ಬಾಟಮ್ ಡೇಟ್ is 1811. Now 1611's notice which they even posted to me on 2011, they have already put it on for auction on 1811.
Auction was to be held on 2811.
2811 and they say 1811 they have already put it for auction. I have not even been put to notice. And now if your lordship may kindly see, along with my petition, I have produced the panchnama of my car being seized. Page number 52, my lord, Annexure V1.
52.
Please, my lord, along with the 52 of the petition.
Huh.
1511 is the date my car is seized.
1511.
Panchnama 1511.
Yes.
Toyota Innova anta 1511 they seized that.
Yes.
And Annexure F 1611, I have given a representation to them saying whatever is the amount that is to be regularized, I will pay. As against Innova, there is no due. Please grant me opportunity. NP ಅಂತ ಮಾಡಬೇಡಿ, ಪೂರ್ತಿ ಎಲ್ಲ 4 ಅಕೌಂಟ್ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ತೀನಿ. 4ಅಲ್ಲಿ anyway this is not NPA Innova ಇರೋದು, I will pay ಅಂತ I give a representation. In fact, there is a reply from them on 20th asking me to regularize it, which is at Annexure G, page 58.
Page 58.
58, my lord. There is an email.
Yes.
If I may read that portion, my lord, with reference to your letter, we have to inform you that as per RBI guidelines, if one account is NPA, all other accounts are marked as NPA, even if the repayment for other accounts are coming. Hence, following RBI guideline, we have seized your car. We request you to regularize the SME term loan account in order to avoid further action in the matter of seized vehicle. This they are giving it to me on 20th of November.
After putting it for
ಅದು auction ಹಾಕಿರೋದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ, because technically ಈ 20th ನೇ ಆ notice ನನಗೆ ಸರ್ವ್ ಮಾಡಿರೋದು. The first notice they claim is also sent only on 20th. I have not received it at all.
ಆಮೇಲೆ
So therefore, my lord, I am here before this court seeking regularization. When I am before this court, this petition is filed on 4th of December. Then they say on 19th that it is already sold. Then they filed this memo.
I have captured all this in the
Please, my lord. Therefore, the sale is absolutely done without no notice to the person. And of course, that Innova against, there was not even one EMI pending.
Yes. Yes.
My lord, the first and foremost thing is that our allegation matter it is that sale has been taken place on 18. That itself is a wrong submission. That for that
Paper publication.
paper publication published on the usually paper publication top ಅಲ್ಲಿ ಏನಿರುತ್ತೆ ಅದು ಆ ಡೇ ಪಬ್ಲಿಷ್ ಆಗಿರುತ್ತೆ. ಆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಯಾವಾಗ ಫಾರ್ಮೆಟ್ ಕೊಡ್ತೀವೋ that format we have given
Paper publication ಅಲ್ಲಿ 18th ಅಂತ ಇದೆ. ಅದು ತಪ್ಪಾ?
ತಪ್ಪು. ಅದು ತಪ್ಪು ಅಂದ್ರೆ ಅವತ್ತು ದಿನ ಆಕ್ಷನ್ ಮಾಡಿದೀವಿ ಅಂತ ಅಲ್ಲ. My lords, I'll come to that point.
Don't think this court would not understand that. 18th is the day on which you have given it to the paper for publication. The auction is supposed to be held on 22nd. Correct?
No.
ಯಾವತ್ತು auction ಮಾಡಿದ್ದು?
My lords, on 28th we have put it for auction.
When was the auction done?
28th only.
28th.
8th only.
The date on which the auction was fixed.
Yes, my lord.
Correct.
My lord, before that, earlier date of appeal, this court has asked me about the NPA. See, auction ಎಲ್ಲ ಆಮೇಲೆ ಬರುತ್ತೆ. Let me prove on the NPA only. When the court has asked me, it is my duty that I
have not asked you anything.
ಅಲ್ಲ, last date of hearing NPA ನೇ ಆಗಿಲ್ಲ, ಹರಕೆರೆ ನೀವು ಎಲ್ಲ ನೀವು
I have asked questions to Vignesh which he has answered. I have not asked you any question.
That question was asked me only. If it is asked to the Vignesh Shetty, it's my duty that I should prove before the court.
Not necessary.
No, because of wrong submission of regarding the NPA only, all these things have been
No
happened.
problem. Yes.
I may be heard on this, my lords.
Absolutely.
My lords,
Tell me.
NPA, regarding NPA, my lords, as the
ಎಷ್ಟು ಸೇಲ್ ಆಗಿರೋದು?
They claim it is 23 lakhs.
18
lakhs is
lakhs
the amount due. They have to state
At least 20% cost impose ಮಾಡಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
please 23 lakhs is what they say.
5 lakhs cost impose ಮಾಡಿದ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ.
18
ಹೇಳಿ
lakhs.
madam.
My lords,
Tell me, yes.
yeah, before going to NPA, my lords.
No, you said NPA, first go to
Yes,
NPA.
yes, my lords. Madam, I am filing a memo along with the RBI guidelines where it is been mentioned regarding the NPA. Based on that RBI guidelines only, all the banks should act.
Correct.
I am just giving that.
And don't tell me rudimentary things in this court. If you do not know anything, learn. This court is aware that RBI guidelines ಎಲ್ಲ ಎಲ್ಲ ಮಾಡೋದು. That's all right. Now tell me.
Saying that this court is not aware.
Now tell me.
It's my
RBI, that's all right. RBI guidelines ಪ್ರಕಾರ ನೀವು ಮಾಡಿದ್ದೀರಾ. ಅದನ್ನ ರಿಪ್ಲೈ ಹೇಳಿದ್ದೀರಾ. RBI guidelines ಪ್ರಕಾರ ಒಂದು NPA ಆದ್ರೆ ಎಲ್ಲ NPA ಆಗುತ್ತೆ ಅಂತ. You want to tell that? Leave it. Yes.
my lords. If
I have
the
heard
court is
Vignesh Shetty enough and more. I am just giving you audience, that's all.
Please
Only to impose costs. Yes.
No, my lords, please don't repeat the word that I have already been heard Vignesh Shetty. because
Definitely.
my-
Orders I have recorded.
Orders,
I have recorded every
my lords,
order.
my
In
lords,
every order what
I'll tell
Vignesh
my
Shetty has
lords,
said.
ನಾನೇನಾದ್ರೂ wrong
This is
my
highly,
lords,
I am not on you, madam. Highly unfair practice on the part of the bank. So bank will be saddled with costs. Definitely.
my lords,
ಎಲ್ಲ ಆಗಿ dictating orders ಅಲ್ಲಿ ಇದ್ದು dictating ಮಾಡ್ಬೇಕಾದ್ರೆ you change the counsel and try to say something else.
for that
No.
I'll give a justification for that,
No,
my
no,
lords.
no, I will not accept. I need not accept every justification of the bank. Yes.
My lords, if anything asked for me, then it is my duty that
I have not asked you anything.
Alla bank, see, I'm the bank here.
You're not the one who was there earlier.
I'm representing the bank, my
No,
lords.
no, you're not the one. You're not the one who was earlier here.
Correct, my lords.
Get Vignesh Shetty, I will hear everything. Yes.
My lords, when the invoice is given, then how?
No, no, I'm not.
Vignesh Shetty
That is what will be for imposition of costs on the bank.
My lords, if wrong submission made before this honorable court, obviously that order based on that submission only court has passed. That itself.
So you're telling Vignesh Shetty has made wrong submissions.
That is why.
All right.
That is why, my lords. I am.
Record that also. You're telling Vignesh Shetty has made wrong submissions.
Please record it, my lords.
Yes, I will.
See, based on.
Anyway, it's on live streaming. It will be recorded.
Please, my lords, please. For that only I'm here. Because for that only, see, I was not knowing all this thing which has happened earlier. When the bank has come to me by, along with the invoice.
Your officer is here?
My lords.
Your bank official is here?
He was here only.
Let him become aware.
Yes, my lords. Agli,
5 lakhs will be the cost.
yes, my lords. If it is proved that we have done anything.
Nothing. Yes.
My lords, when they came to my office along with the invoice only, I got to know all this thing.
Bank cannot play smart here, madam.
Bank only explained everything that.
They are
this-
before a court of law. This is not.
Let them be, my lords.
Yes, let them be.
No, my lord, because they have
What
to,
let them be?
if they are, my lords, sorry, nange wrong information kotre, obviously my submission also will become wrong only. Let them give a right, right instructions for me so that my argument will be in the right way only.
Now, whatever on merits you want to tell fast.
Merits, my lords, before getting into the merits, I want
Before
to argue.
getting only on the merits.
My lords,
Before
I am-
the court has got into other things 20 occasions earlier.
yes, my
yes.
lords, I followed by the judgments, I wanted to argue on the maintainability of this honor.
Yes,
case.
Kodi. Writ petition is not maintainable.
My lords,
ಆಮೇಲೆ
ಎಲ್ಲರೂ ಕಾಪಿ ಕೊಡ್ತೀನಿ ನಿಮಿಷ. My lords, in page number 1.
Yes.
Yeah, PHR Invent Educational Society versus UCO Bank and others.
Paragraph.
My lords, I have highlighted in the first part only that.
First para is head note.
Yeah,
You take me to the paragraph.
yes, my lords. That head note only I have highlighted.
Head note is not written by the judge. It
Yes,
is by
my
the
lords.
publisher.
Yes, my lords.
Go to the paragraph.
I'll go to the paragraph. My lords, in page number 8, para 14. There also highlighted. The law with regard to regarding to entertaining a petition under Article 226 of the Constitution in case of availability of alternate remedy is well settled. In the case of Satyavati Tandon Supra, this court observed thus. 43 point. Unfortunately, the High Court overlooked the settled law that the High Court will ordinarily not entertain a petition under Article 226 of the Constitution if any effective remedy is available to the aggrieved person, and that this rule applies with greater rigor in matter and involving recovery of taxes, cess, fees, other types of public money, and the dues of bank and other financial institutions. In our view, while dealing with the petitions involving challenge to the action taken, recovery of the public dues, etc., High Court must keep in mind that the legislation enacted by Parliament and state legislatures for recovery of such dues are a code unto themselves in as much as they not only contain comprehensive procedure for recovery of the dues, but also envisage constitution of quasi-judicial bodies for redressal of the grievance of any aggrieved person. Therefore, in all such cases, the High Court must insist that before availing remedy under Article 226 of the Constitution, a person must exhaust the remedies available under the relevant statutes regarding the jurisdiction. And though they have a merits, if so for that also there is a separate order, my lords. Kindly see page number
16.
no 26. Sorry, 23, my lords.
Hmm.
This is the judgment of. I'll read the cost statements. High Court of Delhi judgment, my lords. Sanjay Dhingra versus IDB Bank Limited and others,
Yes.
page number 23,
Yes.
point 9.3,
Mm.
where a remedy is available under section 17 of SARFAESI Act. This court ought to not to entertain writ petitions under section 226 of Constitution law, and even on merit. The case of the petitioner is not sustainable. The petitioner had approached this court preliminary on the ground that since the loan was issued from the Dubai branch, proceedings under section SARFAESI Act would not be maintainable. In similar circumstances, Bombay High Court has already held that these issues ought to be properly agitated under section 17 of SARFAESI Act before the debt recovery tribunal, my lords. So when such being the case,
Not maintainable.
yes, my lords, if the petition is not maintainable, of course I'm on the merits only. Bank has not done anything wrong here.
Mm.
Bank has followed all the SARFAESI measures, but it has to be discerned before the DRT, my lords, as per these judgments also. I've given more than 3 more judgments. Kindly go through it. I don't want to waste the precious time of this honorable court.
No problem.
Before this honorable court, I
No, no,
will
you
make it.
finish. You ಏನೇನ್ ಹೇಳ್ಬೇಕೆಲ್ಲ ಹೇಳಿ.
That's all, my lords. I've
ಅಲ್ಲ
given-
ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಏನೇನ್ ಹೇಳ್ಬೇಕೆಲ್ಲ ಹೇಳಿ.
Yes, my lords. In the third judgment, sorry, in the fourth judgment, also the same para is repeated in this judgment, which I have regarding the High Court. If there is a well settled law, the High Court should not. It is mentioned in page number 48.
Hmm.
Well settled law is available, then the High Court has no jurisdiction. It is like that.
Hmm.
In the last judgment, my lords.
Hmm.
The same para has been repeated in this also, but it is Kerala High Court that is held
All
in
right.
Satyavati case, and they have referred Satyavati case, and so
Satyavati is the basis, madam. There are many judgments written on after Satyavati Tandon that High Court should not entertain a petition. No, because you are vehement in saying that bank has done nothing wrong.
Yes,
I'm
my
telling you. See, Supreme Court has also said that where there is statutory violation, a writ petition even under the surface would be maintained. Even in its latest judgment, Supreme Court says so. Why statutory violation I'm saying is, basic thing is, before you initiate any proceedings of seizure, sale or whatever, the borrower must be notified, correct?
yes, my lords,
Ah.
because of that only will
Correct.
communicate
ಹೌದಾ?
to notice.
Borrower notify ಮಾಡಿದ್ದೀರಾ ಇದ್ರಲ್ಲಿ. ಅಷ್ಟೇ
ಮಾಡಿದ್ದೀವಿ.
ಯಾವಾಗ ಮಾಡಿ?
My lords,
After giving the paper publication
yes, my lords.
on 18th of whatever date it is, for the sale would be on 28th. You issue a notice on 20th. Will that be in accordance with law? That's all. Don't fall prey to these officials of the bank who keep changing the advocates. You should be confident and conscious of what you say. Today, you have stepped in place of Vignesh Shetty. Imposed cost, what will be?
My lords,
What
I don't
will be?
know.
Tell me.
I don't
The
know.
bank will say, because you have come on record, the cost will be imposed. But they will do that. Don't fall prey to the officials of the bank.
Sure, my lords.
That's very important. You're a counsel, I'm telling you.
The thing is, my
These
lords,
people keep changing whatever tune they want. Don't do that.
yes, my lords.
You should have, if
My
Vignesh Shetty is also a counsel.
My lords,
He's
last
also
year
a-
we
he's
had
also a
discussed
counsel.
I know him well.
You
He's
know
my
him.
brother advocate.
One minute. He's also a counsel. You should never utter saying that Vignesh Shetty has uttered falsehood before the court.
No.
That's not correct.
I'm not doing direct allegation. Bank
Direct-
told me such
That
things.
is what I
I'm just
told you.
telling that,
That is why I told you. Don't fall prey to these officers of the bank.
yes,
And
I do understand.
mudsling another advocate. Tomorrow they will go to another
My
person.
lords, this is my 16th year of practice.
Ah,
I
then
saw so
ಯಾಕ್
many,
ಬೇಕು ನಿಮ್ಗೆ
I saw so
ಬೇಕಾಯ್ತು?
many managers or officials.
Why do you
like
need
this.
all that?
See, they have been told me that when the court has told me that have you aware of the Vignesh Shetty submission and all the need, and how you got the NOC, and when it is my duty that I have to convey the
That's
message.
okay.
That's it.
You have
I don't want to.
done your duty. No problem. We will answer.
And one more submission, my lords, one more request. In fact, rather than submission, I'll consider this as a request. See, ನಾನು ಬೇರೆ ಯಾರೋ advocate ಏನು ಮಾಡಿದ್ದಾರೆ ಅಂತ shouting at me in the open portal, I think that itself is
No,
unfair.
that's not
because I'm
why I
such a
did.
here.
Nah, this is why. This is why I said it was not shouting on you. It was on the bank. Advocate should not take the time shouting at them. I never shouted any advocate.
My lords, ತಾವು ಕೇಳಿದಾಗ ನಾನು ಏನಿಲ್ಲ 4 o'clock ಅಂತ ಆಯ್ತು, but list ಅಲ್ಲಿ mention ಇರಲಿಲ್ಲ. Probably
That's
ನಾನು
all right. No problem. That is
was
all
my
right.
concern.
That is all. Now, see, no court would have entertained any submission of this kind because further hearing, if you change the advocate, that itself would draw adverse inference against the whoever employer it is or the bank, whoever it is. I permitted you to argue. Yes, you want to make submission, you make submission. But that is not. And any shouting will be only on the on whom you represent, not on the advocate. Not on the advocate at all. I've never shouted on an advocate. Will never do it unless situation warrants. Okay. Now you ಹೇಳಿ ಏನ್ ಬೇಕು ಹೇಳಿ. Yes.
My lords, this court has told me that even there is a statutory violation.
Hmm.
According to me, there is no statutory violation at all.
Hmm.
As rightly, court has told me asked me that, have you intimated the borrower regarding all this?
ಅಷ್ಟೇ. That's all.
Yes, I have intimated.
Where is
And yes, my lords.
ಕೊಡಿ.
Kindly peruse 1 second. My lords, there are 2 statement of objection has been filed. One is for R1, one is for R2.
Hmm.
R2 file ಮಾಡಿರೋದ್ರಲ್ಲಿ it is on the legal notice, page number 34, that is annexure R3. Legal
Page.
notice, page 34, my lords, 34.
10/7/23.
Yes, my lord.
Ada? Hmm.
In that legal notice also, we have clearly explained everything regarding the NPA and also regarding the guidelines of the RBI, how your accounts has been considered as a NPA, though it is regular.
Because
though it is
ಒಂದ್ರಲ್ಲಿ
regular.
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಆಗುತ್ತೆ. That's what you have said here.
Yes,
Hmm.
and moreover, my lords, ಈ legal notice allenella, when he has come to the bank approaching a loan, since from the loan agreement, we have been intimating him ಇದಾಗುತ್ತೆ, let it be the 1 or 2 ಅಲ್ಲ. If you taken a 10 accounts, 10 loans, if one account
That is correct. That is RBI guideline.
see, ಅಂದ್ರೂ they have saying that ನಾವು ನಮ್ಗೇನು intimation ಬರಲಿಲ್ಲ, they have considered NPA.
Madam, this is-
Ignorance, my
One
concern is
minute.
that,
This is notice. Before you put a property to auction, now we know why is a property here. should not the borrower be notified of such auction?
It's been
ಇದು
notified.
notice ನೀವು NPA ಆಗುತ್ತೆ ಅಂತ ಕಳಿಸಿದ್ದೀರಾ, no problem. This is not notice that is necessary in law. Beyond this, I can't tell you.
No,
This is
before-
not the, then you make your submission, I'll consider it.
My lords, since from NPA only, we are supposed to intimate to the borrower this is how. And before getting into NPA, 1 month skip adagale, we used to say that it is not a demand notice. The word itself will say the demand. We will not demand anything. One month agid takshana, you have a risk. In another 2 months only, it will skip into NPA and we have to proceed along with the law. Alinda start ಮಾಡ್ತೀವಿ request ಮಾಡಕ್ಕೆ. And when the third notice will be reached to continuously 3 months ಆದಾಗ NPA ಆಗುತ್ತೆ. After that, we will send demand notice. We are not requesting anything you. As we have earlier sent that, earlier we have sent so many notices regarding the request. ನೀವು regularize ಮಾಡಿ ಅಂತ. Now we are demanding you through the statutory notice only. My lords. So ಇಲ್ಲಿ ನಾವು statutory notice ನ under section 32 ಕೊಟ್ಟಿಲ್ಲ. As per the SOP of the bank. ನಾನು SOP ನೀನು ಕೋರ್ಟಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ along with the memo. Guidelines ಮಾಡಿ. This is the SOP, my lords. I'm serving competence. Madam.
Madam.
But I'm not being served a copy of any of the memos, my lord.
No, I'll give right now itself because I got
Bank
two
has
copies.
disowned you. Yes. No vehicle is in your possession?
Yes, my lord, it's under my possession.
Yes.
My lords, in SOP, page number 3, my lords. I violated over there. In the page in bottom of the said page number, the bank will hand over the possession of the asset to the borrower anytime after repossession, but before concluding the sale transaction, provided the bank dues are cleared in full or a compromise settlement has been reached between the borrower and the bank. My lords, even though sale has taken place, as this court has confused, sale has been taken.
Confused?
Yes, my lords, because the earlier submission, that's all. 1811 ಅಲ್ಲಿ sale taken ಆಗಲ್ಲ. It was on
18th
25th.
sale ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
28th ಆಗಿರೋದು.
28th, sale has taken place, not the property sold. See, even after
Sale
that,
has taken place, whatever, on 28th.
yes, my lord, sale has taken place. And after that, as per the SOP, and I'm producing sale certificate before this honorable court, along with the memo.
Another memo?
Sale certificate, it is not there in the file. By oversight, it has not been given. So that will show that when the sale is confirmed.
11/12/23.
28 ತಗೊಂಡ್ ಆದ್ಮೇಲೆ as per the SOP as I read now, even till ಇವತ್ತು ನಾಳೆ confirmation ಆಗಿದೆ, till today he'll be having all the rights to close his account and to recover his property, whether the car or whether the mortgage, something like that. So we have confirmed the sale on 11/12/2023. More than that 15 days, he has a sufficient time, another 12 days. What were he doing? And when you have been, what is that? You have been legally injured by the bank. What prevent you to go and approach DRT? It is into 23 only. When it was in the November time only, he did not approach DRT. He wanted to drag the matter because High Court case ಹಾಕಿದ್ರೆ ಅದು reach ಆಗಕ್ಕೆ ತುಂಬಾ time ತಗೊಳುತ್ತೆ. First of all, court ಮುಂದೆ ಬರಲ್ಲ. This is what their conception is. DRT ನಲ್ಲಿ date will be given by default and same day ಆಗುತ್ತೆ and I'll stay ಕೊಡಲ್ಲ. This is what the concept of the other side, like petitioners. That is why it's my humble submission, my lords. They have not come with clean hands before this honorable court.
Yes.
Point out one thing in the SOP that they have just given. ಕೆಳಗಡೆ ಪಾಯ ಮಾತ್ರ ಓದೋದು.
ಮೇಲ್ಗಡೆ sale.
ಮೇಲೆ ಅಲ್ಲೇ ಕ್ಲಿಯರ್
Sale of
ಆಗಿದೆ.
vehicle ಅಂತ
After repossession ಒಂದು ಫಾಲೋ ಮಾಡಿರೋದಕ್ಕೆ ಅವ್ರು justify ಮಾಡಕ್ಕೆ there is absolutely nothing. Because
sale of vehicle.
the sale of vehicle it should be the third notice. ಅದಕ್ಕೆ ಮುಂಚೆ reserve price fix ಆಗೋದಕ್ಕೆ 7 days valuation ಆಗಬೇಕು ಅಂತ ಹಿಂದಿನ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ. ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ after repossession within 7 days first valuation ಆಗಬೇಕು. 15/11 ಪಂಚನಾಮ, 16/11 notice. ಅದನ್ನ ಡೆಲಿವರಿ ಪೋಸ್ಟ್ ಮಾಡಿರೋದು 20/11. ಅಲ್ಲೇ before effecting a sale a notice of minimum 7 days to be given to the borrower.
My lords,
There is absolutely nothing stated.
ಅವ್ರು ಇಷ್ಟ ಮಾಡಿದ್ರೆ ಇಲ್ಲ.
There is absolutely nothing stated in the entire argument as to where is the compliance of their own SOP, where is the compliance of the due notice. That is my simple case when it comes to the sale of Innova.
Yes.
And
then
one
yes.
other submission, my lord, they just showed a 10/7/2023 notice ಅಲ್ಲಿ ದುಡ್ಡು ಕೇಳಿದ್ವಿ, notice ಆಗಿದೆ ಅಂತ. That stood cancelled because 10/7 is that notice. Subsequent to that annexure R5 irregularity notice ಕೊಟ್ಬಿಟ್ಟು regularize ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಅವರೇ ನಮಗೆ ಬಂದು ಹೇಳೋದು. R5 is issued, 10/7 is this notice. R5 is issued to me.
27/10.
27/10. That is the basis for me to approach this court because I cannot go before the DRT seeking to regularize my account. Illi irregularity notice ಕೊಟ್ಟು 27/10 ಗೆ 7 days ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಂತ they come for seizure. Therefore I requested an additional week's time to say that ಪೂರ್ತಿ amount of regularization I'm willing to pay, give me some time ಅಂತ. ಅದನ್ನ ಕೇಳೋದಕ್ಕೆ I cannot go before the surface court. And in that irregularity notice is the last communication to me. And they have sold the vehicle.
Yes madam, ಕೊಡಿ madam.
my lord, let's make something before this.
ಮತ್ತೆ
Lords,
ಆಯ್ತಲ್ಲ.
Yes, ಅಲ್ಲ ಅವರು intimation ಇರಲಿಲ್ಲ, reserve price fix ಮಾಡಿದಾಗ. These are all internal procedure of the bank. No need to send a notice regarding the reserve price fix because that reserve
ಪ್ರೈಸ್
price
ಬಗ್ಗೆ ಏನು ಹೇಳಿ?
ಅವ್ರು ಹೇಳಿದ್ರು 7 days ಅಲ್ಲಿ ಅವ್ರು ನಮಗೆ ನೋಟಿಸ್
That is
ಕೊಡಬೇಕಿತ್ತು.
your SOP ಹೇಳಿದ್ದು.
SOP ಅದೇ ಆ SOP ನಲ್ಲಿ we are supposed to send a notice ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಆ ತರ ಅವ್ರು ಕೊಡಕ್ಕೆ ಏನು necessary. And ಏನೇನು reserve price fix ಆಗಿರುತ್ತೋ that will be in the auction notice only. And moreover, my lords, if I come to conclusion that as this court has said, ನನಗೆ last time ಅದೇನಿದೆ you have to give the vehicle back ಅಂತ ಹೇಳಿದೆ. What could be the consequence? ಅದು ಒಂದ್ಸತಿ ನೋಡೋಣ within 1 minute.
ನೋಡೋಣ.
Yes,
ನೀವು
no, my
ನೋಡಿ.
lords, no, ಆ ತರ ನಾನು ಏನಾದ್ರು ಕೊಟ್ರೆ, see, account is closed from the purchaser. not from the borrower.
Purchaser is also here.
ಅಲ್ಲ ಅದೇ
Hmm.
ಅವರು ಇವಾಗ ನಾನು ಏನಾದ್ರು ವೆಹಿಕಲ್ ಅಫ್ಕೋರ್ಸ್ ಆಸ್ ದಿಸ್ ಕೋರ್ಟ್ ಅವರ್ ದಟ್ RTO ನೆಲ್ಲ ಇಂಟಿಮೇಷನ್ ಕೊಟ್ಟು ಇಟ್ ಇಸ್ ನಾಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ಹಿಸ್ ನೇಮ್. ಸೊ ಸ್ಟಿಲ್ ಇಟ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ಸ್
I'll tell you one thing.
ದಿಸ್ ಇಸ್ ಕನ್ಕ್ಲೂಷನ್ ಮೈ
I'll
ಲಾರ್ಡ್ಸ್.
tell you one thing. Conclusion early. Don't think this court is powerless to undo everything. These are all trivial official acts which will straight away be blown by a writ order.
I do understand.
So
that, my lords.
don't harp on that.
I know, I do understand. The
Yes.
thing is, ಇವಾಗ ನಾನು ಅವ್ರು ಕೊಟ್ರೆ they are not supposed to take the vehicle back
No
because
problem.
because
That
let them pay. ಇವಾಗ ನಾನು
What order should be passed, I will pass. Nim submission ಏನಿದೆ ಅದು ಮಾಡಿ.
Yes, ma'am. That's only
ಆಯ್ತಾ?
no, in one last submission.
ಹೇಳಿ.
So ಅವ್ರು ಏನಾದ್ರು ವೆಹಿಕಲ್ ನ ಅವ್ರಿಗೆ ವಾಪಸ್ ಕೊಡ್ಬೇಕು ಅಂತಂದ್ರೆ this account is closed for 49 lakhs odd. ಅದನ್ನ ಅವ್ರು ಪೇ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. So ಅವಾಗ ನಾನು ಅವರಿಂದ ತಗೊಂಡು
We'll see about all that. That's a
Ha.
consequential action.
because account is closed from the purchaser, not from the borrower.
We'll see.
Lord,
Yes.
my submission is that, my lord, the loan was declared as an NPA on 29th June 2023, my lord, 29th May 2023. Lord, subsequent to that, there was a seizure notice, which is the impugned document which is being challenged by the petitioner dated 2nd June 2023.